Today, as part of our ongoing commitment to keeping you informed, we're here to share some exciting news that could have a significant impact on countless lives in the United States. In this video, we're delving into a promising development regarding the October Visa Bulletin prediction for 2023. So, whether it's morning, afternoon, or evening in your part of the world, we're delighted to have you here. If you're eager to dive deeper into this topic, we invite you to stay with us until the end of this video. If you find our content valuable, please consider hitting that subscribe button, giving us a thumbs up, and don't overlook the bell icon to ensure you receive instant updates directly on your YouTube feed. Now, let's dive right into the video to explore the latest updates regarding U.S. immigration. Welcome once again. Any alterations in the Visa Bulletin's predictions can carry significant consequences for those currently seeking employment-based visa. The Visa Bulletin holds a crucial role in determining the availability of green cards for employment-based visa applicants. Recently, several members of Congress have taken action by sending a letter to Secretaries Blinken and Mayor Koss, urging them to bring all the dates featured in the Visa Bulletin up to the present, facilitating the creation of a filing date chart. This potential update could have substantial ramifications for employment-based visas and the backlog of pending cases. In their letter to Secretary Mayor Koss and Secretary Blinken, the congressman underscores the importance of highly skilled individuals to the U.S. economy, especially those in STEM fields. They acknowledge the historical backlog of outstanding cases and the competitive landscape with countries like Canada in attracting international STEM talent. Given these considerations, the congressman has proposed to the administration that starting from October 1, 2023, all employment-based visas be brought up to date on the Visa Bulletin. Understanding the impact requires delving into the approved I-140 petitions, although not all applicants may currently be waiting for their green cards. Conversely, if all employment-based visas had been updated on October 1st, none of the 140,000 available green cards for that fiscal year would have been distributed. Therefore, it's challenging to predict how many green card applicants will ultimately qualify due to various factors, including approvals, denials, and changes in employer sponsorships, which introduce uncertainty into the process. The congressman strongly emphasized the importance of preserving the opportunity for all eligible candidates who have already received approval for their I-140 petitions to submit their I-485 adjustment of status applications between October 1st and October 31st. By following this approach, the administration can ensure that there are sufficient applications for each available green card, effectively preventing the wastage of visa numbers, a problem that has persisted in recent years. In the letter, historical precedent takes center stage as it highlights the practice of using the Visa Bulletin to gauge interest in green cards. An example is drawn from the administration of former President George W. Bush, who brought all the Visa Bulletin dates for July 2007 up to date. The congressman believes that the United States Citizenship and Immigration Services or the Department of State could potentially implement this recommendation without requiring congressional approval, thereby increasing the likelihood of its adoption. However, while this plan presents several potential advantages, it also raises some important considerations. Bringing all the dates on the filing date chart up to date could, in effect, grant applicants a de facto green card, allowing them to live and work in the United States without a visa while their actual green card applications are being processed. This may lead to an influx of applicants eager to take advantage of employment authorization documents and advance parole benefits based on their impending adjustment of status, which warrants careful consideration. This situation could potentially diminish the importance of non-immigrant visas like the H-1B and L-1, as applicants might be able to directly seek adjustment of status once their I-140 petitions are approved. This could lead to the elimination of the requirement for employer-sponsored non-immigrant statuses and possibly even the filing date chart itself. If the USCIS decides to completely do away with the filing date chart, applicants may no longer have to worry about maintaining non-immigrant statuses or participating in visa lotteries. Instead, adjustment of status could become a direct path to permanent residency, offering a new opportunity for a significant number of people. This plan could open doors for individuals from countries with backlogs, providing them with an opportunity they previously couldn't attain: applying for adjustment of status, obtaining employment authorization documents and advance parole, and subsequently having the freedom to work and travel without the need for a visa while awaiting their green cards. The letter penned by the congressman and submitted to the secretaries hints at a potential shift in visa processing methods. It raises questions about the future of non-immigrant visas and the implications of de facto green cards. While this proposal presents exciting prospects for many applicants, only time will tell whether the recommendation will be adopted and put into action by the USCIS or the Department of State. We're eagerly anticipating how this situation unfolds and will make sure to keep you updated with any new developments as they arise. Staying informed and prepared for potential changes is crucial, especially as we eagerly await the official release of the Bulletin. During this waiting period, we'll remain vigilant for any updates and eagerly anticipate sharing further insights with you in the near future. A group of lawmakers has united to compose a letter urging the inclusion of all employment-based visa dates in a visa bulletin for the filing date chart. This letter was addressed to Secretary Mayorkas and Secretary Blinken. This proposed change could have significant implications for green card availability and the existing application backlog. The congressman stressed the importance of highly skilled immigrants, particularly those in STEM fields, to the United States economy. The plan to bring all employment-based visas up to date as of October 1, 2023, aims to reduce the backlog while simultaneously attracting foreign investment and talented individuals. However, this move may raise concerns about the future of non-immigrant visas and the potential consequences of de facto green cards. That concludes our update for today. We hope you found this video informative and helpful. We're committed to staying vigilant on all U.S. immigration-related developments and will bring you fresh videos whenever there's new information to share. The U.S. Immigration Update channel is your go-to source for all the essential visa details and procedures to navigate your U.S. immigration journey. Understanding the various steps in the United States immigration process, visa application requirements, processing times, necessary forms, fees, and more is crucial. We'll continue to provide comprehensive information on a wide range of topics, including U.S. visitor visas like B1 and B2, work visas including L1A, L1B, and H1B, student visas, green cards, immigrant visas like EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. We appreciate your visit today, and we look forward to seeing you in our next video. If you haven't already, please consider subscribing to our channel for more updates on U.S. immigration. Thank you for your support.